I'm Carrie Felice, Probate Department Chair with Elder Needs Law. Whether or not a probate case will be required to transfer real property owned by your loved one will depend on how they held title to the property. Any real property that your loved one owns solely in their name, even if it was their homestead, will require a probate to transfer that ownership interest to their spouse, their children, or even to someone they named in their will. If your loved one co-owned real property with another person or persons, the way that they held title will determine whether a probate will be necessary. There are three main ways to co-own property with another in Florida. The first is what we call a tenancy by the entireties. This is a co-ownership of property by spouses. If your loved one took title to property jointly with their spouse, it should somehow state in the deed that they are a married couple. If it does not, so long as they were married at the time they acquired the property in the same deed, and they acquired an equal interest in the property, they're presumed to hold title to the property as tenants by the entireties. Property owned as tenants by the entireties has full rights of survivorship, so the ownership of the property passes automatically to the surviving spouse without the need for a probate. There's another form of co-ownership of real property recognized in Florida that provides rights of survivorship and also avoids probate. This is a joint tenancy with rights of survivorship. It's a way that unmarried people can jointly own property and ensure that the co-owner of the property automatically inherits the ownership interest of the decedent. In order to create a joint tenancy, there really just needs to be words in the deed like with rights of survivorship, with full rights of survivorship, something along that lines. And as with the tenancy by the entireties, each owner's interests are equal and they have an equal right to possess and use the property. And also, just like a tenancy by the entireties, the ownership interest of the decedent will automatically pass to the co-owner or owners. Now, the last type of co-ownership is a tenancy in common. And this is the default type of co-ownership for unmarried people. So in the absence of language expressly granting survivorship rights, unmarried co-owners of real property will be tenants in common. Property held by tenants in common can be owned by any number of co-owners, and they can each own any percentage. The percentages do not have to be equal. Now, the other big difference between a tenancy in common and either a joint tenancy with rights of survivorship or a tenancy by the entireties is that when one of the co-owners passes away, their interest passes to their heirs, not to the co-owners of the property. So therefore, if your loved one owned property with others as tenants in common, their ownership interest in that property will need to be probated to be transferred to their heirs. If your loved one owned real property and you're unsure whether a probate is required to transfer their interests, please call us today to schedule a probate consultation. I would be happy to assist you.